Please find a seat. We'll get started. There are some seats in the front. All right, good afternoon, everyone, and welcome to this panel discussion of stare decisis and civil rights cases. My name is Diane Sykes. I serve on the Seventh Circuit Court of Appeals in Chicago, and it's my pleasure to moderate this panel discussion this afternoon. Thank you. Title VII of the Civil Rights Act of 1964 makes it unlawful for an employer to discriminate against any individual because of such individual's race, color, religion, sex, or national origin. Some of the Supreme Court's interpretations of this transformational statute have been controversial. Notably, the Court's 1971 decision in Griggs versus Duke Power Company, which recognized a theory of liability under Title VII for employment practices that are facially neutral, that is, they do not discriminate intentionally, but have a disparate impact on racial minorities or persons in another protected class. And the Weber and Johnson cases in 1979 and 1987, which permitted employers to use affirmative action practices that entail intentional discrimination in favor of racial minorities or persons in another statutorily protected class. The Griggs disparate impact principle was codified in the Civil Rights Act of 1991. The Court's affirmative action precedents remain on the books, but can be difficult in application, as was seen most recently in the Court's 2009 decision in Ricci versus De Stefano. In this respect, our foundational anti-discrimination law continues to elude stable construction. And just last month, the Court heard arguments in 3 cases that require the justices to consider whether Title VII's ban on employment discrimination because of sex covers discrimination because of a person's sexual orientation or transgender status. Since the statute's inception, the federal appellate courts had uniformly said no, holding that sexual orientation and transgender discrimination are different in kind than sex discrimination. 2 years ago, my court, sitting en banc, overruled that stable interpretation, and the Second Circuit soon followed suit. Now the Supreme Court will decide. The principle of stare decisis is generally thought to have stronger force when applied to statutory questions than to constitutional questions, largely based on the rationale that it is far easier for Congress to override statutory precedents than it is for the people to override constitutional precedents by amending the Constitution. Our panel will discuss stare decisis in the context of statutory civil rights cases. Our panelists are well known to you, and time is short, so I will keep the introductions short. Professor Nelson Lund will start our conversation. He's on my far right. He is the university professor at the Antonin Scalia Law School at George Mason University, where he teaches constitutional law and related courses. Professor Lund graduated from St. John's College and holds a master's degree from Catholic University, a PhD from Harvard, and a JD from the University of Chicago Law School. Neil Kinkoff will follow him. Professor Kinkoff teaches at Georgia State University College of Law, where he specializes in constitutional law, civil procedure, and legislation. He has also taught at the law schools at Case Western and Duke. Professor Kinkoff holds a bachelor's degree from Boston College and earned his JD at Case Western Reserve University School of Law. Next in line is Michael Carvin, to my left, a trial and appellate specialist at the Jones Day Law Firm here in Washington, D.C. Mr. Carvin is a leading member of the Supreme Court Bar, having argued 10 cases and counting, and he has argued in almost every federal appeals court in the country, including my own, before panels including yours truly, your humble moderator, and I will resist the temptation to interrupt him with questions almost immediately. Mr. Carvin holds a bachelor's degree from Tulane University and a JD from George Washington University School of Law. And finally, we'll hear from Professor William Eskridge, Jr. He is the John A. Garver Professor of Jurisprudence at Yale Law School, where he teaches courses and writes on topics in constitutional law and statutory interpretation, among many other areas of expertise. Professor Eskridge holds a bachelor's degree from Davidson College, a master's degree from Harvard, and a JD from Yale Law School. With that, I will call on Professor Lund.
Thank you very much, Judge. It's an honor to be here. Quotas and preferences for racial groups and for women, for favored racial groups and for women, have become an established feature in the modern workplace, largely because of two Supreme Court decisions, Weber and Johnson, that rejected the plain language of the Civil Rights Act of 1964. In 1991, Congress either overruled those decisions or at the very least deprived them of precedential authority. Now, in order to explain how that happened, I'll have to give a little background. Title VII of the '64 Act, by its terms, forbids employers to discriminate against any individual because of such individual's race, color, religion, sex, or national origin. This obviously applies to intentional discrimination, whether it's overt or covert. In the Griggs case in 1971, the court unanimously held that the statute also prohibits unintended adverse effects on racial groups whose members are disproportionately lacking in the requisite qualifications for a job. The court then created an exception for practices that resulted in racial disparities that are smaller than some unspecified large magnitude. And finally, even if there is a sufficiently large disparate impact, the court said the job qualifications set by the employer are permissible if they have some unspecified business justification. There's no hint of these exceptions in the statute, which is not surprising since there's no hint of the disparate impact rule to which they are exceptions. Nor was there any support for any of this in the legislative history. The Supreme Court just made the whole thing up. 8 years later, in Weber, the court legalized intentional discrimination. The case arose from a program adopted in a collective bargaining agreement designed to train some of the employer's unskilled employees for higher paying skilled jobs at the company. Slots in the program were limited, and the slots were to be allocated by seniority. Under pressure from the Federal Labor Department, however, the employer and the union agreed to an exception from the seniority rule by imposing a 50% quota for black workers. The plaintiff in the case was a white worker who had more seniority than some of the black workers who were admitted to the program. At the outset of the majority opinion, Justice Brennan acknowledged that the quota violated what he called the statute's literal language forbidding discrimination because of race. Most of his opinion was devoted to arguing that the overt racial discrimination entailed in this racial quota was consistent with what he called the spirit of the statute. Brennan purported to find evidence of this spirit hiding behind other provisions of the text and in the legislative history. Justice Rehnquist's dissent systematically demolished every bit of this supposed evidence and proved that the court had introduced into Title VII a tolerance for the very evil that the law was intended to eradicate. 8 years later, the Johnson case gave approval to a preference given to a white woman over a more qualified man. Once again, Justice Brennan wrote the majority opinion. Weber had relied on evidence that Title VII, entirely on evidence that Title VII was meant to address what was called in the opinion and in Congress in '64, the plight of the Negro in our economy. And its holding extended only to measures aimed at eliminating racial imbalances. Unable to invoke stare decisis in Johnson, Brennan claimed that Weber should be extended beyond its holding because Congress had not overruled it. Justice Scalia's dissenting opinion skillfully refuted all of Brennan's arguments, much as Rehnquist had done in Weber. But I want to focus on the fact that Johnson's rationale for preserving and extending Weber rested entirely on a single proposition, namely that Congress had tacitly endorsed Weber by failing to overrule it. I think that theory is plainly fallacious, but if we assume that it's correct, it follows that Congress can also tacitly remove or repudiate the tacit endorsement that Brennan attributed to the legislature's post-Weber inaction. And that's just what the Civil Rights Act of 1991 did. This statute resulted from a bitter two-year debate about a series of employment discriminations from the Supreme Court in 1989. Most of the controversy arose from efforts to codify a very aggressive disparate impact theory that the Supreme Court had rejected. Proponents said they were trying to restore Griggs. Opponents defended the Supreme Court decisions that had interpreted Griggs more narrowly, and opponents also called this a quota bill that would force employers to use racial preferences to avoid the imbalances that could trigger disparate impact liability. In the end, Congress codified the disparate impact theory in an extraordinarily ambiguous form. This allowed both sides to claim victory in public while privately lamenting the outcome. But the statute made a number of other changes to Title VII as well. Most important for my purposes today, Congress added a new provision to the statute. It says, and I'm quoting, "Except as otherwise provided in Title VII, an unlawful employment practice is established when the complaining party demonstrates that race, color, religion, sex, or national origin was a motivating factor for any employment practice, even though other factors also motivated the practice." Now, on its face, this section of the 91 Act overrules Weber and Johnson. Race and sex were indisputably motivating factors in both cases and in every other so-called affirmative action program. The only way to escape this conclusion is by appealing to a savings clause in the 91 statute, which provides, and I'm quoting, "Nothing in the amendments made by this act shall be construed to affect court-ordered remedies, affirmative action, or conciliation agreements that are in accordance with the law." Now, the natural reading of this language would apply only to court-ordered affirmative action, a traditional equitable remedy in which preferences are given to specific victims of proven forms of discrimination. Even if one assumes that the language may apply more broadly, the affirmative action would still have to be in accordance with the law. If Weber and Johnson are the law, the 91 statute becomes internally inconsistent, as well as inconsistent with the anti-discrimination language adopted in 1964. But judicial opinions are only law in a metaphorical sense, whereas Title VII is undoubtedly the law. And Title VII still provides, as it always has, that intentional discrimination because of race or sex is forbidden. Although the 91 Act overrules Weber and Johnson on its face, the legislative history indicates that the new provision about motivating factors was aimed at overruling a different Supreme Court decision called Price-Waterhouse. Nor is there anything in the legislative history specifically indicating that it was also meant to overrule Weber and Johnson. In fact, one of the strangest features of the lengthy process that led to the 91 Act was the absence of commentary on these cases, Weber and Johnson. The debate focused largely on disputes about whether disparate impact liability would lead employers to adopt racial preferences, yet there was almost a conspiracy of silence about the legality of such preferences. Does that mean that Congress has in effect confirmed Justice Brennan's assumption that the legislature's inaction constitutes approval of Weber and Johnson? On the contrary, if Congress can confer approval by inaction, it can just as easily withdraw that approval in the same way. And that's just what happened in 1991, when Congress added or amended at least 22 statutory provisions dealing with employment discrimination. In doing so, it expressly endorsed the controversial Griggs decision, but it chose not to endorse Weber and Johnson. What's more, this is specifically confirmed in the legislative history, which is a lot more than Brennan was able to say in Johnson. A memorandum submitted for the record by 14 senators who supported the final compromise specifically said that nothing in the new statute, including the savings clause, disapproved or approved of Weber and Johnson, and nobody in either house contradicted that statement. Thus, even if one accepts Brennan's dubious theory of approval by inaction, Congress withdrew that approval through its deliberate inaction in 1991. Recall that the text of the 91 statute plainly overrules Weber and Johnson in the new motivating factors provision. Even if one invokes the legislative history to reject that plain meaning, the text and legislative history of the new statute deprive Weber of the precedential authority that the court attributed to it in Johnson. At a minimum, therefore, the 91 statute frees the courts to reconsider those decisions. And since both of them are indefensible on the merits, as Rehnquist and Scalia proved in their dissenting opinions, the courts should now overrule them both. Thank you.
Well, first, I just want to say what an honor it is to be here. This is a really, really great honor, to put it mildly, to appear in such a large room filled with people who think and think deeply about important issues of law and public policy. I'm also quite conscious of being a member of a panel with really deep thinkers about law and about the issues before us. And so, finally, I guess I'm conscious of the fact that this is a lunch talk. And I want to offer food for thought. I don't want to offer, though, a sort of full-blown, filling entree. Instead, what I'd like to offer are some tapas, a few small plates. And the beauty of tapas, of small plates, is they're meant to share, right? So I want to offer a few ideas that I mean to share with the panelists to sort of get conversation going, and also with the room, because I'm really curious to hear what people in the room have to say about the issues that this panel means to cover, right? And those issues, I think, come from the theme of the conference overall, originalism, and the theme of this panel, stare decisis in Civil Rights Act cases. And I think a great vehicle for thinking through originalism, or as we call it in the statutory interpretation setting, textualism, is this set of cases that the Supreme Court took and heard oral argument in a few weeks ago relating to the application of Title VII and whether or not it protects excuse me, LGBTQ people. So, first, I think, what are the values of originalism, right? What values does textualism promote? So, first of all, it promotes sort of formal compliance with the Constitution, right? The Constitution says that laws must be passed through bicameralism and presentment. It's only the words, the text of the statute that go through that process, and so it's only the words that are the law. Right? It is not the intentions or expectations of the drafters that are the law, it's the words of the law, right? The law is what it is, regardless of what the legislators intend. Closely related to that is a rule of law value. Right? So when statutes are understood by the sort of objective public meaning of the words, rather than by the intent of the statute drafters, that constrains law to be law, right? And we are governed by the law and not by the intentions of the lawgivers. We are therefore a government of laws and not of men. Third, textualism constrains judges, right? If judges start looking to purpose, intent, and I think Nelson's talk illustrated this point rather well, it becomes malleable, right? The statute can be made to mean whatever the judge wants it to mean. And so then we end up with a situation where it is not emphatically the province and duty of the judicial department to say what the law is, but rather to say what they would like the law to be. I think these are all strong arguments in favor of textualism. And if we apply textualism to the Title VII case, I think the result is really rather easy. Title VII prohibits employers from discriminating because of race, color, sex, religion, or national origin. If an employer fires an employee because they marry a person of the wrong race, that is discrimination forbidden by Title VII. If an employer fires a person because they marry someone of the wrong religion, that's discrimination in violation of Title VII. If an employer fires someone because they marry someone of the wrong national origin, that's discrimination in violation of Title VII. How then can it not be that firing someone for marrying a person of the wrong sex is not discrimination forbidden by Title VII? Well, one answer that you hear is that Title VII meant to address a different evil, right? Including the word sex was meant to address the evil of sexism, not the evil of homophobia, right? But that's interpreting the law according to its purpose, right? Not a textualist basis for understanding or interpreting the statute. In that respect, the move partakes of the opinion the court issued in the great bête noire of textualists, Holy Trinity Church, where the Supreme Court interpreted labor or service of any kind not to apply to Christian ministers, right, even though they perform a labor or service of any kind, because their labor or service didn't involve the kind of evil that the statute was meant to redress. All right, first small plate. Second small plate, I want to talk a little bit about stare decisis. Stare decisis is the doctrine that courts should uphold precedents. Right? It promotes the values of stability and predictability in the law. It promotes the value of equality in that similarly situated parties are treated similarly. It promotes the constraint of judges, right, prevents them from simply imposing their preferences or their will. And I think most importantly, it promotes the legitimacy, the institutional legitimacy of courts. As a result, courts tend to be loath to overrule precedent. And I think that's been a particularly strong value in the Rehnquist and Roberts courts. Think, for example, of the federalism case, Garcia versus San Antonio Metropolitan Transit Authority. In that case, Justice Rehnquist promised in his dissenting opinion to come back one day and overrule Garcia. But he never did, formally. Effectively, however, he did. But to see how Garcia becomes not such good law anymore, you have to follow through the anti-commandeering doctrine and how it's developed in the years after Garcia. You have to follow the expansion of the understanding of state sovereign immunity far beyond what's indicated in the text of the Constitution. And you have to follow through the court's limits on the scope of Congress's power under Section 5 of the 14th Amendment, which could abrogate state sovereign immunity. But who can follow all of that? Well, certain kinds of very specialized lawyers can. But the problem is, and Garcia is but one example of what I think is a strong trend, it was on the Rehnquist court and is on the Roberts court, of instead of overruling precedents, distinguishing and limiting them to death. Right? And the problem with that approach is that it undermines transparency. right? Only very specialized lawyers can see what the court is doing. And so in this connection, I want to raise another case that the court has taken this term, and that's the Louisiana abortion case. Now, I don't know why the court took that case. I don't pretend to know the court's mind. But I do think that case is being taken at a time when it's easy to look around the country and see that many states have adopted sets of regulations that are designed to make the provision of abortion services virtually impossible, right? Death by 1,000 regulatory cuts. And it's my hope that as these cases and as this background comes to the court, if the court is going to overrule Roe versus Wade, that it does so expressly, right, in a way that's transparent and the public can know. I think that's something that's very contrary to the, to the instincts of Chief Justice Roberts, right, because I think he's so committed to preserving the legitimacy, the public standing of the court. But I think it's really important for the court to do that forthrightly if that's the direction it's going to go in. Third plate is Trump versus Hawaii, right? The travel ban case from last year. Now, Trump versus Hawaii sort of fits under the heading of stare decisis, I suppose, because at the end of the opinion, the Supreme Court struck down the ancient and notorious case Korematsu, which upheld the Japanese internment camps during World War II. And I think that's an interesting sort of counterexample to what we typically think of with respect to stare decisis. In that instance, I think striking down the precedent, overruling the precedent, actually enhances the standing and legitimacy of the judiciary. But I raise the case also because I think it's an important case from the standpoint of doing statutory interpretation in the context of presidential power. Right, and three of us on the panel used to work at the Office of Legal Counsel, where interpreting statutes relating to presidential power is something you do almost every day. And so I think the court's decision in Trump versus Hawaii is a really important one in that it shows that the court is inclined to extend a great deal of deference to the president's interpretation of statutes and to the president's exercise of power pursuant to statutory authority. It provides an interesting counterpoint, I think, to the court's current hostility toward the Chevron doctrine, because it looks an awful lot like Chevron only for the president. Now, it's interesting that Chevron has never been interpreted as applying to the president, and that Chief Justice Roberts, before he was appointed to the Supreme Court as an appellate court judge, actually noted that in a concurring opinion and said that he would apply Chevron to the president. Right? And so what we get is this doctrine of great deference to the president, and there are reasons that that's a good thing, but there are things to be concerned about relating to it as well, and I think the Chevron sort of comparison illuminates that. Right? So the concern would be great deference to the president's authority under statutes is apt to relieve the president of legal constraints. Right? And so if you think of a president that you don't like, then that kind of deference to presidential power is a troubling thing. If you think about it in the context of presidents you do like, then you're apt to think it's a good thing. Right? All right, so those are my small plates. Thank you.
Good afternoon. Also good to be here. I'd like to pick up actually on the points that have previously been made, first about Weber and Griggs, and then also about the recent cases that are involving sexual orientation being covered by Title VII. In terms of stare decisis in Title VII, I think the fundamental thing you need to understand that no statute has been so twisted by the judiciary to mean precisely the opposite of what it says. It's really a frontal assault on democracy. In 1964, the nation came together, greatly deliberated this landmark legislation and emerged with a basic moral principle embodied in law, which is that no individual in the United States can be disadvantaged on the basis of irrelevant characteristics like skin color. Within a few years, a handful of judges decided that no, it meant precisely the opposite, that you were required to use race in employment, that you are allowed and required to discriminate against at least non-black employees, and so literally turned the statute that was the embodiment of the democratic process completely on its head to mean the opposite of what its plain words meant. It doesn't take any kind of legal scholar to figure out what Title VII said. As has been pointed out repeatedly, it says, you can't discriminate against any individual because of race, sex, national origin, etc. So, as Nelson's really already pointed out, Weber first took the words any individual and made them different, said, well, any non-black individual, you can certainly discriminate against them. When Congress said any individual, apparently they only meant members of certain select racial groups. That was dismantled, as Nelson's already pointed out, by Rehnquist dissent, both in terms of the language and the legislative history, and the only response by the majority would be ironic indeed that a statute that was intended to help blacks actually frustrated their progress, and as Justice Rehnquist pointed out, that's about as ironic as saying two wrongs don't make a right. So that was the first part of the statute that the judiciary rewrote. The second part was because of race. It said because of race. You can't distinguish between individuals because of race, because of their skin color. And Griggs said, well, no, if you make a distinction that's wholly unrelated to race, say their scores on a neutral, race-neutral test, or whether they've got a high school diploma, that is also now encompassed within because of race. The statute doesn't say because of things statistically associated with race, it says race. And when you convert it into a rule against anything which disadvantages a particular racial group statistically, what you, of course, have done is established a quota system. An effects test is a quota. It says you must hire and promote in proportion to the availability of the particular group in the workforce or the community. So it's an absolute unyielding quota. Now, as Nelson pointed out, they had to make up, therefore, a justification to make it not a strict quota. They were never entirely sure what that justification was, because, again, they had to make it up since none of this was in the statute, and it was variously described as business necessity. If taken literally, that means you need to hire on the basis of quotas unless it's necessary for the survival of your business not to do so, to engage in race-neutral hiring. So this is obviously, as Justice Scalia pointed out in his Ritchie concurrence, in great tension with the Constitution's, the 14th Amendment, requiring people to hire people on the basis of quotas. So that was the second rewriting by the judiciary of the plain language of the statute. Now we are confronted with the third effort to rewrite the statute, and that is, of course, saying that sexual orientation comes within the discrimination because of sex. And it's ironic, as we've heard today, that people who embrace Griggs and Weber have now become born-again textualists, and I certainly welcome them to the party. But listening to them is a lot like liberals trying to be textualists is like children playing with handguns, because I don't really think they understand what this is all about. I don't care if Congress intended to protect homosexuals in 1964, but I do care what was the law they enacted. And the law they enacted was you can't treat people differently because of sex. It didn't say, in plain language, because of sexual orientation. The public meaning of that word is obvious to everybody. If an employer fired every gay and lesbian employee, not one person in the United States would say he's discriminated on the basis of sex. He's discriminating on the basis of sexual orientation. Discriminating on the basis of sex is, for those of you new to the country, a distinction between men and women, and not a distinction between people who are romantically involved with people of the same sex and those who are romantically involved with people of different sexes. And this is so obvious that when the Supreme Court struck down gay marriage, in the Oberfeld decision, not one justice, not one party argued that this is prohibited sex discrimination. Obviously, the 14th Amendment prohibits sex discrimination. If this was remotely a plausible interpretation, all they would have had to say was, this is sex discrimination, discriminating against gay marriage, and therefore we're striking it down. But it never even occurred to anybody to make that countertextual, counterlinguistic argument. Now we fast forward, and it's becoming convenient to make this argument, and we've heard the rationale. Well, you know, if it was interracial marriage, then you discriminated on the basis of someone's romantic partner, their race, that would be racial discrimination. But that's a semantic game, right? Discrimination on the basis of someone's partner's sex is the very definition of sexual orientation discrimination. Obviously, the only distinction between heterosexuals and homosexuals is the gender of their partners. So if you're discriminating against somebody because of the sex of their partner, you're not engaging in sex discrimination, you're engaging in sexual orientation discrimination. And obviously, in the racial context, if you ask somebody, why is the employer opposed to interracial marriage? The answer is race. If you ask somebody, why is the employer opposed to same-sex marriage? The answer would be animus or hostility towards homosexual relationships. So this is purely wordsmithing. This has nothing to do with either the English language, much less the intent of Congress, which again is proved by the fact that for years they've been trying to amend Title VII to add sexual orientation, because that's an entirely different basis of discrimination. And there are many statutes out there which do single out sexual orientation discrimination. So, now to return to the topic of precedent. What do we do with a undemocratic judicial assault on a statute where they've tried to twist the meaning of the words to accomplish liberal goals that were never embodied in the democratic process? With respect to Weber, I think Nelson's made an excellent argument about why the 91 Civil Rights Act requires you to overturn that. I'd also point out that since we're all textualists now, since everybody on the court this term has claimed that it's the text of Title VII that governs regardless of intent, that means you have to overturn Weber, because Weber said, no, the spirit was overruling the letter. Finally, of course, Weber's entire rationale, as Nelson pointed out, was that Title VII was designed to overcome the history of segregated workforce in the United States. Well, Title VII was enacted 55 years ago. We were in our third generation of living under Title VII's regime. So we have eliminated all of these vestiges of segregation. So the rationale for continuing Weber after its goal has been accomplished vanishes. It's kind of like in the Michigan cases where the Supreme Court said we're going to end diversity in 2025 or whatever it was. It seems to me the end date for Weber has come and should be done. Griggs is a little more complicated because of the 91 Civil Rights Act. I can't bore you with this. Nelson's entirely right. Their endorsement of disparate impact was extraordinarily ambiguous. So whether or not there's any kind of life to disparate impact, I think, is a dicey question given the 91 Civil Rights Act, but there's two important points. One is, the key under disparate impact is not so much whether or not you have to justify the action, it's what you need to do to justify it. And there was two decisions prior to the 91 Civil Rights Act called Watson and Ward's Cove, where they basically said if you can come up with a rational justification for your test or your hiring policy, then it's okay, which would greatly reduce the quota force of Griggs. And I think there's a very strong argument that the 91 Civil Rights Act did not overturn Watson and Ward's Cove, and that should be done. Plus which, if you don't interpret Title VII's disparate impact to allow the employer to come up with a rational justification, then it does impose this quota regime that Justice Scalia noted in Ritchie, and under the doctrine of constitutional avoidance, you need to do away with it. The decisions this term obviously have nothing to do with stare decisis, but if they're decided correctly, we won't have to confront the mischief that they've created in future years. Thank you.
Well, I think Nelson was the appetizer. Neil, I think you were the tapas. Michael, you were the meat and potatoes. Now, I don't know what that makes me. Maybe I'm the dessert, and I'd like to think a just dessert. So let me pick up on the conversation where Michael left it. Michael, I appreciate your very candid comments. I would say textualism is not for conservatives. My understanding, I was very good friends with Justice Scalia. I'm a great admirer of many textualists, from Easterbrook and Scalia, who founded this. And I can assure you the Justice's view, and I'm pretty sure Frank Easterbrook's view, is that textualism is not for like one ideological group. And so you should be welcoming any kind of political or whatnot use of textualism if you think that it is the most legitimate way to approach statutory interpretation. Now, words like semantics and wordsmithing, well, that frankly is what textualism is all about. That, look, when you pass a statute, you're enacting words. Words have meaning, and the role of judges and the rest of us is to apply that meaning even to new circumstances. Before I go to the stare decisis stuff, I do want to give you a thought experiment for Title VII. And we have put at your table, at my request, a copy of the statute, fragments of it, obviously, and some precedents and some amendments to the statute. So look at the statute. It says it's unlawful for the employer to discriminate against any individual because of such an individual's sex and other characteristics. Now turn it over, and you get 703M, which Nelson has quoted, but it gives it to you in a piece of paper. 706.3M says an employer is culpable of an impermissible consideration of sex, as well as race, etc., when sex is a motivating factor for any employment practice. Now consider these three hypotheticals. Employer fires X. Let's say X is a man, and the employer fires X because X is attracted and dates other men. That's the Zarda case. Let's say X is a black person, and the employer fires the black person because the black person dates Y, who is a white person. That is race discrimination, to discriminate against interracial sexuals. You can play a word game, and say that, no, that's not race discrimination. That's discrimination against interracial sexuals. You can do that, but it's still race discrimination. Let's say X is a Roman Catholic, and the employer is happy to hire Roman Catholics, but you see where I'm going with this, not Roman Catholics who date Protestants. Say Y is a Protestant. You fire X because of the kind of person X is dating or is sexually attracted to. So that's basically the Zarda case in terms of the statutory words. And I would submit that if you want to be a textualist, words have meaning. Justice Scalia, actually, in a very famous opinion, which is cited for you on my handout, in the on-call case, ruled that if an employer tolerated homosexual harassment, which were the facts in on-call, the employer could be held accountable under Title VII. That result might have been unthinkable in 1964, but that result for a unanimous court was suggested by the statutory text. Now, I do want to talk about the topic that Judge Sykes very generously introduced to us, and that is stare decisis and original meaning. And I want to start with some, if I've not already been heretical, I'm going to get there very quickly. Some of the ways in which stare decisis, as the other panelists have suggested, might be in some tension with original meaning, however defined. And I would suggest that if you want to look at the original meaning of the Constitution, stare decisis has got to be considered an important part of the institutional architecture of Article III, an important part of the rule of law and the legitimacy of government. Start with the Federalist Paper number 78, which is the most important document on the debating history of Article III and the guarantee of judicial independence. Federalist number 78 says, and there's a lot more language, but it also says this, to avoid an arbitrary discretion in the courts, it is indispensable that they should be bound down by strict rules and precedents. And there's a lot more. That's not surprising, because we come from a common law tradition where precedent was considered literally law. Now, in interpreting the Constitution, Judge Sykes, I would suggest that what you do, you and your colleagues, when you interpret the Constitution and statutes, you are making law. Now, you're doing the best you can to follow whatever your methodology is, but your precedents are binding law. They're part of the rule of law. And the rule of law is actually very important, and precedent is actually very important, for a second reason that Neil emphasized, and that is they do constrain judges. And I would suggest that precedent and stare decisis constrain judges in two different ways. And I would say the following. One is ex post, and that is that precedent does take off the table and settles certain rules from the statute, sometimes statutory purposes, plans, et cetera, et cetera. But precedent also constrains judges ex ante. Because when you're writing an opinion, a judge who knows that this opinion is going to be binding in the future, including for facts that she doesn't anticipate, stare decisis does press judges to narrow their opinions, to limit them to particular facts, and usually to err on the side of incremental law rather than making big declarations where you don't understand the consequences or cannot foresee them. So I would suggest statutory interpretation, stare decisis, is actually very important and is worth some degree of respect. Now, another point of my little handout that I've given you is to suggest that here's another role that precedent plays. That precedent and statutory amendments work hand in glove for many of the statutes that we like to talk about, like Title VII. And what I've shown you there is not all the precedents. I've not listed Weber and some of the others. There are a lot of other important ones. But a lot of the precedents that are relevant to the Title VII issues, Zarda, that are before the court today. And as you see, precedents sometimes stimulate statutory amendments, as in the case of Hopkins. Hopkins is on the back. Hopkins is the case where the complainant was a woman. Price Waterhouse didn't promote her, not because she was a woman. They had women they would promote, but she was too macho for them. She was not feminine enough for them. She didn't conform to gender stereotypes. Now, many women do conform to them, and that was fine, but she did not, and the Supreme Court ruled two things. Number one, a majority of the court, 5 justices, and possibly 6, Justice White, said she was alleging sex discrimination because of her sex. But number 2, the employer had credible evidence that it had other reasons for not promoting her, and it remanded for a burden of proof that would be on Hopkins to show that that was the main reason. Now, as other people have already said, Congress in 1991 overrode Hopkins, overrode some of these other decisions, but it only overrode the burden of proof part of Hopkins with a much more liberal burden of proof, and that's 703M. But the part of Hopkins that defined discrimination because of sex was not only left alone, but was repeatedly endorsed, including by committee reports. That's of some significance. So that's important. Now, even if stare decisis were not important for the rule of law, formalism, legitimacy, and so forth, it would still have a number of values. And one of them, a very important one, is reliance. Keep your eye on the ball. That if precedents are relied upon by either the public, like Congress, or by private entities like employers, it is an independent reason why precedents should not be easily revisited. That's in addition to all the formal arguments. Moreover, stare decisis, and this was true of the common law, it's true of the constitutional law, it's true of statutory law. Stare decisis does have the theoretical virtue of an orderly, moderate evolution of law that does not yo-yo or whipsaw. And that value of stare decisis also might be here in play in the Title VII cases. What does the Supreme Court do with on-call? That's the homosexual harassment case, Justice Scalia. What does it do with Hopkins? That's the Ann Hopkins gender stereotype case. And then returning to legitimacy, and that is yet another value of stare decisis, is that stare decisis invites the following. It invites an overlapping consensus across time and sometimes across generations. So rather than each generation of judges renouncing the work of their predecessors, particularly when that work has been acquiesced in by Congress, stare decisis suggests for each new generation, what can you learn from the precedents that have already been handed down? How can they be practically applied to the circumstances that we face today? And in particular, not only different generations, but also different political perspectives, applying the same kinds of rules and trying to work out some kind of moderate course. Now let me conclude with this. And that is, of course, there is a cost to stare decisis, and no one believes in absolute stare decisis. Stare decisis is particularly, as I understand it, relaxed in constitutional cases. That's Justice Brandeis's insight. And it's supposed to be rather tight in statutory cases, but there are still some overrulings. Justice Thomas, known to some of you, was at Yale a couple of weeks ago and told this anecdote. A student asked, well, Justice Thomas, what's your view about stare decisis? And he laughed and he said, well, you know, there are many cases where court could say A or it could say B, and I'm okay with that. But there's some cases where the court says Z. Okay, there you are, Nelson. Now, I have a feeling, and then he would maybe monkey with those, I have a feeling that Justice Thomas would also depart for C and D, and you don't have to go all the way to Z for Justice Thomas. Now, I will say that that has not been the Supreme Court's practice, I think, at any point in its history. In other words, where it thinks could be A or B, but I don't think C is in the ballpark, and so I'm going to overrule it. I will repeat, that has never been, to my knowledge, the court's practice in our history. The typical practice has been that in Patterson, we give you the citation of Patterson in the handout, and Kimball, a more recent case. These are statutory cases. And that is that precedents should be overruled only when they were both erroneous and, more importantly, the error is harmful error. That they are out of sync today strongly with the way the law has evolved, and or they are harmful in an affirmative way to the statutory policy. And that's a test that sometimes can be met, and that's what you all are trying to do. Now, I'll finally acknowledge at the end a point that was raised, I think, by both Neil and Michael, and that's also a reality, and that is that stare decisis does not tell justices they cannot evade precedents, distinguish precedents, limit precedents, narrow precedents, expand precedents, et cetera, et cetera. And so there is always room for play with precedents. But I would recommend for you a justice who's not often mentioned anymore at the Federal Society, and that is the second Justice Harlan. The second Justice Harlan, who's one of the great legal minds, I think, in the history of the Supreme Court, and I recommend him to the Federal Society. The second Justice Harlan was someone who sometimes strongly disagreed with where the court was going, and sometimes persevered in his disagreement, was often right. But Justice Harlan's approach to precedent was an approach that asked, what can I now learn from the path of this court's decisions, and how can I best accommodate the law that I am now finding to my now reading of the record in this next case. And I would offer that as perhaps the final dessert.
All right, thanks to all for that, those opening remarks, which were very provocative and thought-inspiring, good food for thought. I think we have a couple of different strands of disagreement and some agreement here from the specific application level in the Title VII cases that are now pending before the court on the sexual orientation discrimination and transgender discrimination issues, but then also at the broader theoretical level. So maybe let's start with the specific and then move to the theoretical. The specific points of disagreement about the currently pending Title VII cases, I think, were touched on by both Neil and Mike, and of course Professor Eskridge as well. So perhaps you'd like to respond to your fellow panelists on that specific issue, and then we'll take the broader approach to the theory of stare decisis in statutory cases.
Okay. Sure. So if it's true that we are all textualists now, I'm reminded of Milton Friedman declaring we are all Keynesians now. And when Milton Friedman declared that, it meant no one was a Keynesian anymore. And it may be that if we are all textualists now, no one is a textualist anymore. And textualism just reduces to wordplay, to games, and so I'm sensitive to Mike's point that, it's a handgun that I, the child, is wielding. But I think when I hear the arguments that Mike makes, they have power, but they don't have power for me as textualism. So, for example, the argument that, well, Congress has considered legislation repeatedly to grant sexual orientation protections. That kind of post-enactment legislative history is antithetical to textualism. But we don't raise it as post-enactment legislative history. We raise it as something that confirms the original understanding of Title VII as having never included sexual orientation. Well, you can tell the jury that that's why you're introducing the evidence and not to consider it for other purposes, but everyone who's ever tried a case to a jury knows that once you get the evidence in, it's going to play regardless of what kind of instruction the judge puts on it or what kind of limitation the instruction attempts to put on it. And so the powerful arguments, and they are powerful arguments, are that the enacting Congress did not expect Title VII to apply to sexual orientation. I think that's probably true, although it was a killer amendment, so they might have been pleased to know it would have that kind of broad application. It's also, I think, true that at the time, it's also true that we think of sexism and sexual orientation discrimination or homophobia as different things. But those aren't in the statute. Those words aren't in the statute. And so to draw that distinction introduces a refinement that itself is not directly in the text of the statute. And so in that respect, I think represents legislating from the bench, right? And I think here I would just go back to the point that Bill made, and that is that when judges decide cases, they make law. They legislate from the bench, no matter how they decide, right? It's inevitable and unavoidable. So we are all textualists now, and I'm afraid that may mean none of us is actually a textualist anymore.
Yeah, I'm still a textualist. And has nothing to do with what Congress thought about, has nothing to do with anything except pulling out a dictionary. Can you hear this? Yeah. Pull out a dictionary. On the basis of sex is different than on the basis of sexual orientation. Those are two different traits. One is prohibited, one is not. Let's apply it to the real world. An employer puts up a sign, says no homosexuals need apply. All are banned. Raise your hand among an English-speaking person. Does that discriminate on the basis of sex? Because of sex. Are people being excluded because they are a man or a woman, or are they being excluded because they are homosexual? Those are two entirely different things. It has nothing to do with whether homophobia was contemplated. It has to do with the basis for the exclusion, which is in the statute. Now, they have realized that when you mean sexual orientation discrimination, you mean discrimination on the basis of your partner's sex. So they come up with this analogy to, well, what about your partner's race? And then they play this word game which distorts the text to say that discrimination on the basis of your partner's sex is discrimination on the basis of sex. But it's not. It's discrimination on the basis of your partner's sex, not because of yours. We tend to blend those distinctions, it is true, in the racial context, because you don't want to penalize people for associating with people of a different race. But at the end of the day, the animus towards interracial marriage is based on race. Animus towards same-sex marriage is not based on sex. It's based on sexual orientation. My final and dispositive point is, if this is true, well, I've actually already made dispositive points, but if all of this semantic gamesmanship is true, that means legislatures are unable to discriminate, to eliminate sex discrimination without banning homosexual discrimination. If sex means sexual orientation and you want to ban sex discrimination, it is, under this theory, literally impossible to do without engaging in the entirely different public policy justification that I am now going to require employers not to take account of homosexuality. And if that is true, then, and there's got to be a distinction between sex and sexual orientation, then that is the most lasting proof that all of these arguments have to be wrong strictly as a textual matter.
Thank you. Go ahead, yes.
Let me talk as a textual matter. Can everybody hear? Okay, in the handout, Michael, I've actually given them a dictionary definition from 1964.
Okay.
So you might want to see, actually, one good thing about textualism is it makes you actually do research. And Webster's Second, which is a pretty famous dictionary, even Justice Scalia liked that version of Webster's, defines sex in a very complicated way. Sure, it can mean sex as biology, but it can also mean sex as gender. This is quoting from the dictionary, 1961, a few years before, and also sex as sexuality. And we give you the exact language in the footnote at the bottom of the handout that is on everybody's table. Okay? So, it is all about words, but it's also all about the way that words come together to convey meaning. So let me just play Michael's word game for a second and make a few corrections. If you put up a sign on a restaurant, as people would have done if they had been so literate, and say no interracial sexuals allowed, that would be race discrimination. You know, even a restaurant or an employer that was willing to hire a white person, but not a white person who dated black people. That would be, you know, race discrimination. Now, Michael's, pretty much his only answer is, hey, my little hypothetical of X and Y, that was only the sex of the partner. Does everybody see how wrong that is? Okay? So if X is fired, okay, well, let me tell you. If X is fired, because X is a man who dates Y, another man, it's the sex of X, the employee. If X were a woman who dated a man, that would be great from the employer who does not like. Does everyone understand that?
I don't.
X is fired because X dates Y. X is a man, Y is another man. Michael says, oh, no, you're fired because Y is a man rather than a woman. You could look at it that way. But you could also look at it as he's fired because X is a man and not a woman. Because an employer would allow a woman who dates men, but not a man who dates men.
In either instance, it's the sex of the romantic
Okay.
partner that is the basis for the adverse action.
No, it's the sex.
No.
It's both. Okay, have you ever heard of the certs debate? Certs is a candy mint, certs is a breath mint. It's both. Okay.
I think many people apply that to Altoids and not certs.
But here's the other thing that's going on. Here is the other thing that's going on. And that is, look, I'm afraid Michael has gotten off on totally the wrong track.
Yeah.
The reason, the deep reason why the sex discrimination argument is hard for some people, but not all people, to get the minds around, is that it lacks, in their minds, symmetry. Race discrimination connects, even against interracial sexuals, connects the classification, the class that's harmed, people of color, and an ideology which we could call white supremacy. One reason why a lot of people, cutting through all of the ridiculousness, a lot of people have a problem with the sex discrimination argument is it seems to lack the symmetry of the Loving versus Virginia argument against different race relationships. And that is that the category, the classification, sex, and remember Title VII is just a classification statute. As Neil says, it does not mention classes, just classifications. But the classification, sex, does not seem to match up as well with the category of people, gays and lesbians, or with the ideology, which sounds like homophobia. Now, the reason why that argument has more traction today is that it is widely accepted, though not universally, of course, that the discrimination against a lesbian because she's a lesbian matches up with the discrimination against a lesbian because she's a woman, because both of them impose rigid gender stereotypes on the woman. And rigid gender stereotyping, if you look at precedent, like the VMI case at the Supreme Court level, is the underlying ideology which modern sex discrimination jurisprudence is aimed against. Now, you don't all have to be persuaded by that, but I don't want you to leave this room without understanding how the semantic word arguments link up with the larger meaning arguments.
All right, I know, Professor Lund, you had a point to make, but Mike Carvin's about to jump out of his skin here, so in the interest of keeping peace on the podium, let's have at it.
Oh, no, I've already thoroughly refuted it. And I'm not going to...
Do you want to address the loving point?
But I was fascinated with this dictionary definition, which, yes, you point out.
Dictionaries will surprise you.
And you say sex has to do with sexuality, and that is true, because sometimes we use sex to mean man or woman, and sometimes we mean sex, to have sex. But what it doesn't say, remotely say, is attraction to the same sex. That's not in the dictionary definition, and that would be the basis for sexual orientation discrimination. Under this theory, if you want to play that semantic game, then anything relating to sexuality would be a prohibited basis. So you couldn't fire adulterers, promiscuous people, people who engage in sexual harassment, because that's all about sexuality. No, this is nothing to do with same-sex attraction. It's just that sex has two different meanings.
May I have a legal response? Yes, legal response. I mean, if the test is jumping out of the chair, I'll jump out of the chair. All right. And ask you to read the dictionary.
I am.
Hush up. I didn't interrupt you.
No,
Please at least
be
polite enough not to interrupt me.
Please, sure.
So read the dictionary. What's the middle term that counsel has conveniently forgotten about? Gender. And this is a legal point, Your Honor. So the legal point is, I think in most of the circuits, almost every circuit I know of that's addressed it, lesbian and gay employees do get the benefit of Price Waterhouse. And so if they're able to show they were harassed or fired because of gender nonconformity, then they have a claim in most circuits, and not just in the Seventh Circuit that has Hively, but in some circuits that do not have a Hively or a Zarda. Now, so at the very least, you've got to think about that as well. That's dictionary definition, 1964. That's the evolution of the statute, and that's binding precedent, which has been, in my opinion, that part reaffirmed in 1991, and then partially overruled in 1991, only with burden of proof. So at the very least, it seems to me, it is problematic to discriminate against gay and lesbian employees because of gender nonconformity. And I would submit it is a very short line between gender nonconformity and dating someone of the wrong sex or gender.
All right, Professor Lund.
I just want, can you hear? I just wanted to add something that's in support of Mike Carvin, not surprisingly, but first I want to note that Bill Eskridge outed me as an admirer of Justice Thomas, and I just want to say that I was a Thomist before it was cool to be a Thomist. Now, the thing I wanted to add was a kind of variation on one of Mike's points, is that the statute doesn't actually say because of sex. It says because of such individual sex, namely the plaintiff's sex.
Good point.
And that's why you can't read it. Look, there was this case recently where the CEO of McDonald's was fired for having sex with a subordinate. And if it said because of sex, you could argue that the text made that an unlawful employment practice to fire him for having sex with a subordinate. You can't do that because the statute says such individuals' race or sex. It doesn't say because of sex or because of race. And that, in my mind, in my kind of Thomistic mind, that means a lot of precedents, some of which were authored by people like Rehnquist and Scalia, are very questionable.
But if that's right, then it doesn't violate Title VII to fire someone because of the race of their partner either. It's not that individual's race. And we can have the hypothetical employer who says, I hire people of all races, but I think they ought to be in relationships with people of their own race, right? That's a permissible reading of Title VII. But once we've read Title VII not that way, not as distinguishing between discrimination on account of the race of the employee, but rather as encompassing discrimination based on animus toward miscegenation, a separate thing from racism itself, related, but a separate thing. Once we understand that term that way, then we have to understand the other terms that are similarly in the same provision, similarly unqualified and categorical in the same way as well. You can clap, it's okay.
That's the Loving versus Virginia point. Is there any other response on that point? Otherwise, we'll move on to the theoretical questions. Okay. We had some.
Okay, I disagree.
Okay, there you go. We had.
I will concur with the judge.
I'm going to keep my views to myself.
That's a first. All right, we had some theoretical discussion about the validity of the principle of legislative acquisition, or acquiescence, I should say. We had some theoretical back and forth about the idea, the concept that stare decisis has stronger force, or especially strong force in statutory cases. I think there was general agreement about the background principles that animate the stare decisis doctrine. I don't think we had a lot of disagreement that it enforces rule of law values and has a constraining effect, or is supposed to have a constraining effect on the judiciary, and that it comes to us from a common law tradition. But there's different pressure points in the argument about how much weight stare decisis deserves in statutory cases versus constitutional cases, and this idea of legislative acquiescence. So are there any responses to what your panelists had to say about that? Yes.
I have nothing but admiration, Nelson, for your presentation. I think Nelson has teed up the Weber-Johnson issue very nicely. I do think, and I hate to be such a harpy on this, I do think you have to read the statutes very carefully, okay? And that's not a lifeline, okay? The first thing is there is more to say on the Weber issue. The statutory, Brennan actually does rely on a statutory text. And using a Scalia-esque principle, and that is that Section 703M, I've just quoted in my thing 703A1, you've relied on that as well. 703J in the original act says that the government shall not require, I'm boiling it down, affirmative action from employers. And Brennan got some juice from that because the Weber plan was a voluntary affirmative action plan and not a government-required one, not court-ordered, not EEOC required, that. And Brennan said the most specific provision on this issue is 703J because it actually does talk about affirmative action explicitly. And because 703J seems to have that allowance that the government can't force it, but employers can choose it, and then you can debate about whether the government is forcing it. It seems to me that text is relevant. And look, this is a serious audience. You need to think about that. And I also want to push back a little bit on section 116, Nelson, that you quoted earlier accurately, of the 91 amendments. You can argue, look, you can argue that 703M, which again I've given you in the handout, read literally, creates problems for Weber. Okay, fair enough. 703M read literally creates even more problems for the view that men dating men are excluded from Title VII. And certainly in the Harris Funeral case, which involves a transgender employee, how can you say firing someone because they're transgender is not in some way motivated by sex of that person? So 703M, if you want to read it literally, can cut lots of different ways.
Just to clarify for the audience, that's the provision that that altered the causation standard for Title VII. Causation can be established if one of the prohibited factors was a motivating factor after 1991.
It's on the very back at the bottom of the handout. Now, here's the other thing, though. 116, which I didn't reproduce, but I will give it to you now. 116 of the 91 statute says, quote, nothing in these amendments made by this title shall be construed to affect court-ordered remedies, affirmative action, or conciliation agreements that are in accordance with law. Now, Nelson, you seem to be reading that to say that it's only limited to court-ordered remedies, court-ordered affirmative action, or court-ordered conciliation agreements. You were reading court-ordered to modify all of the different nouns. Is that right?
I said that's the most natural reading. I didn't say it's the only possible reading.
No, it's not the most natural one because conciliation agreements, I honestly can't name a conciliation agreement I know of that was court-ordered.
Well, but I believe they are often enforced by courts.
Well, but it's not court-ordered conciliation agreements. And affirmative action, remember, under Weber and Johnson, never involves, those cases anyway, court-ordered affirmative action. Weber and Johnson were in those cases, and in Ricci, I think, as well, voluntary affirmative action.
Well, right, but that's why the savings clause might not apply.
So the way I would not read court-ordered as a textual matter to apply to each of the three nouns. I just don't think it applies to conciliation agreements. I can't. I would say that 116 is a broad legislative acquiescence. It's an explicit textual acquiescence passed by Congress, signed by the President, in the existing, in 1991, which means Johnson, means Weber, the existing law as regards voluntary affirmative action. Not court-ordered affirmative action, but voluntary affirmative action. I'm at least suggesting that. I hope everybody understands the textual argument there, and we've not reproduced it in the handout. But you can find it in 1991 amendments. It's section 116 at the end of the statute, not that part of the statute.
It doesn't necessarily, my point was only that it doesn't necessarily mean that. And in addition, the words affirmative action might not necessarily apply to intentional discrimination. It was often used prior to 1964 to make outreach efforts and making sure we're open and so on. So what I would rest my argument on more than what I think is the ambiguous textual language on court-ordered affirmative action is rather the phrase that are in accordance with the law. And my claim here is that Weber and Johnson are law only in a metaphorical sense, and Title VII is really law, and therefore Section 116, the savings clause, doesn't save Weber and Johnson.
Well, the Congress that passed the 91 Act did consider Weber and Johnson to be statements of the law.
They didn't say that in the statute.
Well, I know, but they said what I just read, which is pretty close, honestly.
All right, we'll continue this discussion, but those of you who have questions, if you would find one of the microphones, there are two of them in the room, I'm told. So please step up to the microphone, one of the microphones, if you have questions for the panel. Do any of you have any responses to what we've just discussed about the 1991 amendments? All right, well, let's go to questions then. Yes, sir, right here.
Good afternoon, John Birch, and in full disclosure, I argued in the Supreme Court on behalf of Harris Funeral Homes, one of the trio of Title VII cases. Thank you. So I have a thought experiment for Professor Eskridge with respect to Harris, but first, three important clarifications I want to make about the sheet so that no one leaves the room with a misunderstanding about Title VII and its precedent. First, with respect to the dictionary in 1964, gender and sex were synonymous back then. That's why famously on the Basis of Sex movie, Justice Ginsburg changed the reference to sex everywhere in her brief to gender because they meant exactly the same thing. So how some people conceptualize gender today as being malleable, easily changed, and not tied to biology was not what the dictionary was referring to in 1964. Second, in Price Waterhouse, the company absolutely was discriminating on the basis of sex. It wasn't that women generally were able to get promotion to partnership and macho women were not. In fact, of the partners or the associates who were up for partnership that year, class of '88, she was the only woman. And what the Supreme Court actually said in that case was not that macho women have a claim for sex discrimination, but that you can use sex stereotyping to prove sex discrimination, which they defined as treating one sex worse than the other because of sex. That's a very different understanding of that case. Finally, in on-call, the context of that same-sex harassment is important. Justice Scalia emphasized that the supervisor, who was a male, was gay. And so if there was a female subordinate, she would have been treated differently because of sex than the male subordinate, just as if you had a case of opposite sex harassment. So this wasn't an expansion of Title VII, it was simply applying the exact concept, one sex being treated better than the other because of sex, to a same-sex harassment situation. So the thought experiment goes like this. Say the funeral home received a job application, and it has a box on it to check whether you're male or female. And the applicant crosses that out and instead writes that I am transgender and I will not comply with the company's sex-specific dress policy based on my biological sex, or even based on my sex assigned at birth. And the employer decides not to hire that person because of that statement. They have no idea what the actual sex, male or female, of the applicant is. It's entirely because of their transgender status declaration and their refusal to follow the sex-specific dress code. So in that instance, where the employer doesn't even know the sex of the employee, how can you say that's sex discrimination in the way that we would have understood that in 1964? I would note that when Pam Carlin, in the Zarda case, was asked a very similar question by Justice Alito, if the employer didn't know the sex of an employee but discriminated against them based on orientation, she said that would not be a Title VII violation.
Oh, okay, there's a lot in there. Let me say a word about the gender thing. I think, John, by the way, we know each other a little bit because I'm doing a book on the marriage debate. And John was a very important player in the marriage debate. He very capably argued for the states in Obergefell. And our book has a lot of praise for him. You look at the dictionary, and when we say sex is gender, we give you the quote from the actual dictionary. So you should read that. The quote actually is, sex means, among other things, the sphere of behavior dominated by the relations between male and female. And sex, therefore, had this broader understanding of gender characteristics, what we would today call that, and not just pure biology, and also not just pure sexuality. On the Price Waterhouse point, again, in the handout, we give you the quotations. The way Brennan, for the four in the plurality, and O'Connor, the fifth vote, characterized what Hopkins was literally complaining of. And so just like the words of the statute are important, the actual words of the judicial opinion are also important in stare decisis, I would submit. And I agree with you on on-call. What's striking about on-call is that homosexual harassment was considered actionable under Title VII. And I agree with my good friend John that, yes, the Scalia opinion, I would go further than you did. You were not quite far enough. That the Scalia opinion then remanded it to the lower courts to determine whether or not the discrimination against Mr. On-Call had been because of sex. So he actually left that question unanswered. Now, in your thought experiment, my doctrinal answer to that, and I'm just a law professor, my doctrinal answer to that would unfortunately have to be, let's read the text of the statute. And if your exact hypothetical were posed to the employer, I think the answer to that would have to be in 703E2, that any claim of sex discrimination, if that's what the employee actually then makes, can be met by an employer if the employer shows that sex or religion or whatnot was a bona fide occupational qualification for the job that the employer was asking you to do. And it's a defense, it seems to me, that would often or sometimes be available in some of these cases. So that's my statutory answer.
That would be an affirmative defense. I don't think that's quite the
But
same
that's
as
the answer.
Professor Carlin's answer during the oral argument, which
Oh,
said
I
that's
don't-
not a Title VII violation to begin with, if I'm understanding the arguments correctly.
Well, here's my view on the bathroom issue, if you want my view on that. Again, it's the text. 703A does not create a violation unless you show that it's a material condition of your employment, like you're fired or something. And so on the bathroom issue, under Title VII, as I read the text, employers have a lot of discretion in determining how they figure out the bathroom issue. I think what they would have to do is, if other employees have access to bathrooms, they would have to have a bathroom access somehow to transgender employees, as well as other kinds of employees.
So they could fire a man for going into the women's bathroom? Yes?
Sometimes.
All right, let's go to the back microphone.
Thank you, Your Honor. John Vecchione, cause of action. I think part of the textualist of analyzing the text is analyzing what they were doing when they made sex discrimination and put sex in there. And this entire effort, we've lived under this for so long, but usually there was a regime of liberty. You could hire and fire for any reason or no reason at all. And all of these, I think one of the panelists called it was a killing amendment. It was supposed to be about race, and then Congressman Smith put in all these words because he thought, this is ridiculous, no one will go for that. But the time had come to get rid of race discrimination, so they just all voted it up. And my point in all this is, as a textual matter, since they're taking away liberty, shouldn't the textual interpretation be more strictly construed? In other words, if Congress is going to take away a liberty that you always had, you should know that it's doing it, and they should know that it's doing it. And this whole debate shows that just because we don't know this was happening, the tie should go to liberty, meaning that it is not sexual orientation discrimination, because there was a regime of liberty, and when you're going to take that liberty away, it's strictly construed.
All right, who'd like to take that one?
Sure. So I think that's not a textualist argument, right? That's an argument for construing the text in a way that advances a substantive value preference, right? And so you're proposing a canon of statutory interpretation that may be laudable, but it is not sort of a neutral, objective understanding of the text. It's sort of like the avoidance canon, right? Avoid infringing liberty. And so in that respect, I think it's just not a textualist argument.
So it's a substantive canon, it's not a
Right.
linguistic canon. Right. Okay, all right. I'm sorry, did you have something to add?
I agree with what Neil has said. John Vecchione was a student of mine at Georgetown, so he's clearly picked up a lot of good statutory learning. But I agree with Neil that he didn't learn textualism well enough from me. But also, the statute itself, in the 91 amendments, for example, the statute itself does have statements of purpose. The 78 amendment, which we give you in the handout, sets forth this proposition, that pregnant workers, but I think it's more generalizable, but they do put it in the text, should have opportunities based only upon their ability or inability to work. Title VII, though limited to the categories, the classifications, is a statute about your ability to have a job and keep it should be based upon your ability or inability to work as their baseline. Now, again, limited by the classifications, admittedly. So I would also add that.
All right.
I would maybe
Sure.
one slight counterpoint to that, which is it's true that the 91 Act has statements of purpose. They are as exquisitely ambiguous as as so many of the other important provisions in the statute are. And let me add one other possible way to defend the kind of presumption of liberty that the questioner wants to invoke, which is by noting that the constitutional basis for Title VII in the Commerce Clause is pretty dubious on its own, and so that might in some way provide a rationale for being careful about construing Title VII with unnecessary breadth.
I'd like to make a legal correction.
Sure.
And that is, if I may invoke Judge Bork in these halls. Title VII was amended in 1972 to expand, including the sex discrimination provisions, to state, local, and federal employees. As you know, Congress cannot do that under the Commerce Clause, at least to state and local. Judge Bork, when he was Solicitor General, right after he'd been a Yale law professor, argued to the U.S. Supreme Court in a sex discrimination case, Fitzpatrick versus Bitzer, that the expansion to sex discrimination was constitutionally supported by the 14th Amendment. And I believe in an opinion by Justice Rehnquist, the Supreme Court unanimously agreed. So I would slightly amend that the Title VII rests upon both 14th Amendment and Commerce Clause foundations.
All right, next question.
Given that we are all textualists now, how useful or how much stare decisis or precedential values are the cases that previous to the 1990s that did not engage in a lot of textualism in interpreting current cases before the court, especially when the parties are making heavy textualist arguments?
Yeah, it's an interesting question. I mean, we haven't talked about another provision, civil rights provision, which is the Voting Rights Act, where there's all kinds of case law that's completely divorced from the text. With respect to Title VII specifically, though, I think I would embrace the test that Professor Eskridge was advocating, which is you rarely would want to overturn precedent, particularly in the statutory context, unless it's erroneous and harmful. And Weber and Griggs are not only extraordinarily erroneous, they're extraordinarily harmful. It's not as if they expanded the statute beyond what Congress really contemplated. They completely made north-south and took a statute, as Justice Scalia has pointed out, into a powerful engine of discrimination for what was supposed to be an anti-discrimination principle. So whether you're looking at the second Justice Harlan or anybody else, there's really no standard of overturning prior precedent that would not condemn both Weber and Griggs.
All right, back microphone.
Hi, Tarek Malouf, University of Pittsburgh. My question's for Professor Eskridge. In your X's and Y's example, you compare a homosexual man to a heterosexual woman as a way of finding discriminatory behavior. Why do you think that's a more appropriate comparison than comparing a homosexual man to a homosexual woman? And how is it not, as Judge Sykes wrote in the Hively dissent, loading the dice by changing two traits at once?
Well, the answer to that's pretty simple. You could make the same argument for the interracial sexuals. And indeed, wait a minute, the Supreme Court, actually, that was the law of the land for about 100 years. The Supreme Court in Pace versus Alabama confronted an interracial sexual prohibition as a criminal law in that case. And it was claimed to be a race discrimination in violation of the newly enacted 14th Amendment. The Supreme Court said, no, this is not a race discrimination because black people are treated the same as white people. And the appropriate comparison, would be that. Now, that was Pace versus Alabama. Pace versus Alabama was a basis for Plessy versus Ferguson, was overruled finally in McLaughlin versus Florida and Loving versus Virginia. So that way of thinking actually predominated for much of our history on the issue of race. And I would submit, is that because people were not able to think right or didn't understand grammar? No, of course not. It was based upon social meaning. That as long as an apartheid idea dominated much of the country, and the idea that the races were different and should not be mixed, and often these were inspired by religion, as long as that dominated the country, Pace versus Alabama was completely logical. Once that had been discredited by the 1960s, that was no longer an argument that could be made. And I might add, in Title VII, every court of appeals I know of, and Judge Sykes, correct me if I'm wrong, every court of appeals that I know of that's explicitly addressed the issue of different race couples under Title VII. In other words, X is discriminated against not because, but because X is involved in an interracial relationship or attractions. Every one of those cases, the courts of appeals have held that to be a violation of Title VII, of the race prohibition in Title VII. Now, what I suggested before was that the social meaning of here, X and Y, has evolved more slowly. And there's not consensus, I understand. But that's my answer.
If I could just make one comment on Pace versus Alabama. If I recall correctly, that was a unanimous decision in which Justice Harlan agreed with everybody else on the court. I could be wrong, but I think that's the way I remember it. And by the time you get to Plessy versus Ferguson, this body of law had become completely detached from the text of the Constitution. So it's certainly true that once they left the text, they went way beyond Pace versus Alabama and rejected that. But that decision was unanimous at the time and very hard in any reasonable way to dispute on the basis of the Equal Protection Clause as opposed to substantive due process, which took over eventually in the Supreme Court.
All right, next.
Hi, very interesting panel, thank you very much. The Title VII deals with 5 classifications. 3 of those 5 are race, color, and national origin. Race and color are very similar. I mean, I get they mean different things, but I think they're very similar. And had they dropped color, I think courts probably would have interpreted race and color to be the same thing. Can't be sure of that, but that's my guess. And I think there's a strong argument that national origin would encompass all 3. But still, Congress listed those 3 classifications, however similar they listed them. And again, I make the argument they're very close. I'm not sure you agree, but I think they are. Homosexuality is not a new phenomenon, and I believe they probably knew about it back in the 1960s, yet they didn't list sexual orientation. If it's to be interpreted, if sexual orientation is to be interpreted to be sex, I guess one would argue that those 2 are closer together than race and color. Do you agree with that? I mean, do you really believe that sex and sexual orientation are closer together than race, color, and national origin?
Go ahead.
For Mr. Kinkov, but anyone can take it.
So, I guess, so is this sort of a textual argument that because Congress elaborated race, color, national origin, it would have done the same thing with sex and sexual orientation?
Yes.
Yeah. So, I guess we're ascribing to Congress, right, an intent. So we've already left textualism. In terms of the public meaning, certainly our understanding of those terms and categories has changed dramatically over time, as has our understanding of the term sex, terms like sexual orientation and gender identity, which I'm not sure gender identity as a term would have made a lot of sense to Congress in 1964, the way it makes perfect sense to us today as something to talk about. So I'm not sure as a textual argument that gets us anywhere. I think what the court, or what...
They didn't list it is what I'm saying.
Right, so I guess what I would ascribe to Congress in listing race, color, national origin is a desire to make sure they didn't leave anything out, right? Just belt and suspenders, and nothing more than that.
Well, they
and
are
I don't
different.
think that tells us much about what the public understanding, the public meaning of sex was with respect to sexual orientation. And so I think it's plausible to say on the face of it, it doesn't include sexual orientation, but only if we're also willing to then go back to the interracial marriage point with respect to race or color or national origin. And so I'm not sure that that actually gets us anywhere.
What argument is that? Interracial?
It's the loving argument that
You could
we
be,
think
we could be fired for.
If we didn't accept loving, right, if we didn't accept that firing for interracial marriage or interracial relationships is race discrimination, then I think it would be a much stronger argument to say sex refers only to biological sex, doesn't include who you have sex with, right? But once we accept that race goes there, I don't see textually how we get to the conclusion that sex doesn't.
This was briefed in the Title VII cases. Sexual orientation was not a term that was used in common parlance, and certainly never in statutes in 1964. So they wouldn't have done that. There is a little technical point as well. The Supreme Court addressed kind of a similar issue, not the same one you're raising, in El-Ghazari. It's a decision interpreting the Civil Rights Act of 1866, which prohibits discrimination based on race in contracting and property. And the question was, did it apply to ethnicity and national origin? And the argument that was made was that, no, it couldn't, because the Civil Rights Act of 64 and other statutes had explicitly said race or national origin or color, et cetera, et cetera. The Supreme Court unanimously rejected that argument in El-Ghazari and said, no, race, we're going to interpret race to include national origin because that's the object, the purpose, et cetera, et cetera. So that's the kind of move I'm talking about.
All right, the back microphone.
Hi. I think Mr. Vecchioni's good question about the presumption of liberty raises the issue about the absurdity doctrine. And I'm curious how this panel would suggest a textualist should approach the absurdity doctrine, namely the idea that when ascertaining original public meaning, the plain text controls, except when it would lead to absurd results, which to a 1964 audience would probably have been absurd to think that this plain text means orientation and transgenderism and these other second and third degree ideas.
Anyone want to take that one on? Go ahead.
You know that I can. Great question. Great question. Bingo. Here's a problem with it. One problem with it. What is the operative date for original meaning? The plaintiffs in these cases are relying on Section 703A1, true, passed in 64, and on Section 703M. Now, when was Section 703M passed? It was passed in 1991. So if you want to ask, would it be absurd? Normally the question, the way Justice Scalia would ask it, is it absurd in current circumstances? I suppose he'd be friendly to your variation. But even if you want to ask it as an original meaning question, would it be absurd in 1991? The answer is clearly no. 1964, you make a good point.
All right, last question.
Thank you. Starting with Mike, but for the panel as a whole, Mike, you opened the door to this. In one of the Michigan cases, Justice O'Connor said that we ought to wait 25 years and this whole diversity edifice will fall down on its own. Should we wait 25 years or just clean it out now?
Oh, yeah, no.
In higher ed.
Right, that's a reference to the affirmative action cases from Michigan. Go ahead.
Right. No. I mean, that it's really bizarre, right? Michigan cases were bad enough. The Texas case was absurd. I mean, they basically claim they're applying strict scrutiny, but allowing a bunch of, unsupported slogans about the benefits of diversity to perpetuate a racially discriminatory regime, when I was in the Reagan Civil Rights Division in the 1980s, everybody was arguing, look, this is a temporary adjustment to overcome the history of prior discrimination. Now, literally 65 years after Brown, 55 years after Title VII of the Civil Rights Act, you don't hear anybody talking about remedying prior discrimination. It's just a desire for racial balance for its own sake that is ageless in its reach in the past and will continue with us forever. So in 2019, we are talking about perpetuating a regime that divvies us up on the basis of the most irrelevant characteristics, and if that historically divided us, then it is clearly unconstitutional under the Equal Protection Clause, with no justification, and having abandoned the prior justification of this is a temporary adjustment. I'm quite hopeful that the Supreme Court talk about precedent will very rapidly, hopefully in the Harvard case or one of the others, and they really don't have to overturn precedent. They can say, okay, we're applying strict scrutiny, but now we're really applying strict scrutiny, and there's no college preference regime in the country that could possibly survive. So yeah, I think we need to do it now and quite emphatically.
All right, we are out of time. Please join me in thanking the panel.
Thank you very much. That's good. Thank you.